Thank you, Ms. Speed. Next, we're going to hear from Professor Christopher Yukins. Professor Yukins teaches on government contract formations and performance issues, anti-corruption measures, bid challenges, and government contract litigation and comparative issues in public procurement at the George Washington University School of Law. Thank you for being here, Professor.
Thank you, Chairman Graves, Ranking Member Velazquez, and members of the committee. Thank you for the opportunity to speak with you today regarding a potential preference for medium-sized businesses per H.R. 1812, Congressman Connolly's pending legislation. As Chairman Graves alluded to, I'm a professor at GW Law School, and I teach procurement law there. In the interest of full disclosure, I should say that Ms. Northcutt was actually counsel, is actually a former student of mine. I'm very glad to see her here today. The problem the committee is addressing today, the problem of mid-sized firms in the government marketplace, really has two different aspects. First, there is the problem of graduating small businesses, which grow up under the protection of various small business preference programs and then must compete as mid-sized firms without any preferences or protections. Second, and more broadly, mid-sized firms face special competitive obstacles in the federal procurement market, a market which sometimes favors the largest firms, in part because of its steep barriers to entry. There is a perception that mid-sized firms in general face special difficulties in the government procurement marketplace because those mid-sized firms do not have access to the preferences enjoyed by small businesses, and because the mid-sized firms lack the economies of scale and sheer economic and political muscle of the largest prime contractors. There are three possible options to assist medium-sized businesses. First would be to create a preference category called medium-sized businesses. For the reasons I will be discussing, this option, the option of creating a category called medium-sized businesses, could create serious problems in our international trade negotiations. The second option would be to expand the small business size standards to include medium-sized businesses. This is a technical issue, not a legal issue, and it's an issue I will not be addressing today. The third option is to use an innovative pilot program such as H.R. 1812 outlines to leverage existing mentor-protege programs to assist medium-sized firms. Turning to the first option, the question of whether or not mid-sized firms' access to procurement contracts should be resolved by creating a new category called medium-sized enterprises. H.R. 1812 does not squarely present this issue. The bill does not create a new medium category of firms, but instead creates a special pilot program for certain medium-sized firms. But this issue is likely to arise as policy discussions continue. The answer to this question, whether or not to create a special category called medium-sized firms, may lie buried in the World Trade Organization agreement called the Government Procurement Agreement. The WTO members, the World Trade Organization members that joined the Government Procurement Agreement, which is a subset of the WTO, they agreed to open their procurement markets to vendors from other members of the GPA. The United States is a leading member of the GPA, and in fact, the United States has been pushing this initiative to open up procurement markets since just after World War II. China is negotiating accession to the GPA, and India is likely to follow China in joining the agreement. The Government Procurement Agreement, which has been an important part of U.S. trade policy for many decades, is arguably the cornerstone to opening world procurement markets for U.S. exporters over the coming years. The United States, when it joined the GPA, made a number of reservations, including one vitally important to our discussion today. The United States reserved its right to give a preference to U.S. small businesses, even if that meant discriminating against foreign vendors seeking to sell to a Federal agency. The reservation, which is set forth in the United States General Notes to the Government Procurement Agreement, states that, quote, this agreement will not apply to set-asides on behalf of small and minority businesses. So while the United States opened up its procurement markets in general underneath the Government Procurement Agreement, it reserved its right to discriminate in favor of small and minority-owned businesses. The United States has not reserved a right to discriminate against foreign vendors from GPA nations with regard to medium-sized businesses. A new unreserved U.S. preference for procurement from medium-sized businesses would undermine the United States' negotiating position with China and other developing nations, which are seeking broader protections for their own emerging industries before they agree to join the GPA. Moreover, were the United States to create a preference for medium-sized businesses, that preference could trigger a challenge by the European Union or other GPA members under the WTO disputes process. In sum, it could create serious trade problems where we would create this category of medium-sized businesses. That leaves us then with the proposed pilot program for mentor-protege participants. And I talked about some of the practical issues in that in my prepared statement. I just want to briefly touch on a couple of the issues. The first one is whether or not the affiliation rules should apply to companies in the pilot program. The affiliation rules say that if a small business has an affiliation with another company, typically through joint control, that other company's resources should count, and the small business should be considered essentially a larger business. There are two ways this issue could possibly arise under this bill. The first one is if a medium-sized firm were to reach outside to a third party and affiliate with that firm. So a firm less than 1,500 employees, which is a medium-sized firm, were to reach to another firm, for instance, to seek additional capital from that other firm, that could become a large business then. That would be a serious issue that the legislation should address. Another possible form of affiliation, though, would be between a mentor firm and a protege firm. And that kind of affiliation is arguably something the legislation should encourage. So I would argue that the legislation should allow that form of affiliation between mentor and protege. Mr. Chairman, I see that my time is up. I reserve the rest of my comments to my prepared testimony. Thank you.